be transparent up front. I think that's the most important thing. I'd much rather you say, look, there is some danger, there is some risk. Let's be aware of that here, versus making that change, 3 years down the road.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi, everyone. Welcome to this episode of The Defense Never Rests. This morning, I am joined by my partner, Wendy Smith. How are you, Wendy?
Hi, Megan. Hi, everyone.
I'm so glad I have you on again. I love doing podcasts with you. It's just fun.
Thanks.
So today we have the pleasure of having Mike Sidlecki on, who is the VP of Claims at Utica Insurance, or Utica First Insurance, I should say. And also he went to law school with Wendy. So
Roger Williams grad with me.
So I'm extra excited that you two kind of know each other already. And so I'm excited to have a conversation with all you to talk about, Mike actually started off as a plaintiff's attorney and now is a VP of Claims. So he kind of totally switched gears. And he's going to talk a little bit about that. Also the challenges that, he may have and benefits to working at Utica, which is a smaller carrier. So, really excited to talk to him and dive into all that today. Good morning, Mike. Thanks for coming on to the Defense Never Rests today. How are you?
Good, Megan. How are you?
Good. So we have I don't know what you have going on here. I'm in South Jersey. We have this pending snow coming in, which is anywhere between 1 and 6 inches. Are you looking at like a foot of snow up there?
Actually, we're only looking at maybe about 5 or 6 inches, but I'm from Massachusetts and we're supposed to actually get maybe about 12 to 18 inches. We're really supposed to get slammed, I think.
Yeah.
Isn't that like a norm up there though?
It is. It's actually, it's unusual because there isn't any snow on the ground up here in Utica. So, I mean, we're used to a lot of snow. There's actually more snow in Massachusetts right now.
Yeah. And so everyone listening knows Mike is the VP of Claims at Utica First Insurance, and he's up in Utica, New York right now, but he actually lives in Massachusetts. And you plan to drive home today. So that should be an interesting drive for you.
It should be. Yes, definitely. Hoping to get out early enough before the storm.
So we're so happy to have you joining us today. And a little bit of background for everyone listening. Mike and Wendy also went to law school together. And I believe we're friendly or had shared groups of friends in law school.
That's correct.
Same people, yeah.
So my first question is, Mike, do you have any dirt on Wendy that we can...
No.
she's too like perfect. We don't have any dirty facts about her.
I paid him before the podcast. Keep that on the DL.
Is that how you keep your squeaky clean image?
Yeah.
I've got no dirt.
But I love talking about our professors. I mean, that just really brings back a lot of I'd say good memories, maybe some nightmares a little bit, when we were talking about property and, rules against perpetuity.
I still have those nightmares every night. I try to go through them in my head and I always have these dreams about getting called on in class.
Are you one of those people that keeps their law school books?
I am. I still have them.
I have 2, I think. I still have my UCC code. It's actually in my office. And I don't remember, I may or may not have tax. And I do none of that.
I definitely have tax. Tax was actually one of my favorite classes.
Who'd you have?
I had Professor Santoro, God rest his soul. He was fantastic.
That's
fantastic. Fantastic. One of the best.
Well, our tax professor was Professor Maroney, whose son is Dermot Maroney. And we always hoped that, Dermot would come in. He didn't, but. So anyway, Mike, so you're at Utica First, can you give us a little background how you ended up at Utica, like a brief overview of your professional arc? So
absolutely. I started with Utica on June 1st of 2020, right during the pandemic. So things have been a little bit unusual here. I've been coming out to New York. We're planning on ultimately relocating out to New York. Things have just been, strange with the pandemic. We haven't, formally relocated at this point, just, because of schooling and things like that. Prior to Utica First, I worked at Acadia Insurance for about 4 years as a director of claims in Massachusetts. Prior to that, I worked for Hanover Insurance for about 8 years in various capacities, either in subrogation, as a litigation manager, even as a litigation adjuster. And prior to that, I had worked in private practice for a small solo practitioner in Rhode Island, doing mostly personal injury work.
So, and that's what I think is interesting, because it's very rare that, I mean, it's more common that you have someone who worked in private practice that goes into claims. I think it's more rare that you have someone who has actually, worked in personal injury on the plaintiff side and then moves over to claims. Did you work on the plaintiff side when you were doing personal injury work?
I did, yes.
So how was that transition, kind of moving from what, like, in claims, though they're the enemy, they're we're up by our opposing counsel, and then suddenly now you've switched gears completely to the other side.
It was basically like the same thing, those bad insurance companies, they're out to get everybody. That's kind of how things were looked at as, the plaintiff's bar. But the transition, I think, has really gone well. I think it's really helped me kind of provide insight to my claims staff, my claims adjusters, basically, giving them insight as to, what the plaintiff's bar is looking for. And it's also helped kind of mediate some of the disputes. We want to work together to get cases resolved. Cases don't have to be so confrontational. And there doesn't have to be an antagonistic relationship between, the plaintiff and the defense attorney. We can work together to try to get something resolved. So I think that's really been helpful in that relationship. It's also really been easy for me to kind of explain, where things are in terms of damages, how plaintiffs' attorneys look at things, and even to correlate back. Okay, this is how we broke out our damages. We allocated something for temporary disability for 8 weeks. We allocated something for total disability for 5 weeks, and this is where we came up with our number. So it kind of helps in explaining things. And then going back to dreaded civil procedure, it was, a real benefit for me, kind of explaining how the court systems worked, how motions worked, to our staff, and kind of taking them through that process and teaching them. Really, I've taught anatomy of a lawsuit to basically all the adjusters or all my managers, so that they know what to expect from motion practice and how things go as far as that goes.
And a few things that you said actually stood out to me. Like, first of all, I couldn't agree more as to working with your other side. I think you get so much further and so much more accomplished when you're not just like at each other's throat and you're like, okay, we both understand the case. I know what your strengths are. I know, what your angle is going to be. You kind of know where I'm coming from too. Is there a way we can meet in the middle? If there's not, okay, but maybe there is. And I find that you can get a lot further when you try to work together versus like trying to just dig your heels in the sand and make it a full out battle. Not to say there's times that's not needed, but as I think one partner told me, Megan, you attract, more bees with honey.
I think that's a really good way to look at it, definitely.
And so as for, educating your team and, the rest of your claims team, I mean, from your work experience, as a plaintiff's attorney, what did you find that they put more effort into and they really use to push their case for you or drive up value that you now use to educate your team as to, okay, this is, we should be expecting this or that?
I think really in terms of evaluating a case, how to look at, different types of injuries, whether it's a soft tissue injury or something a little bit more serious. Certain carriers use computer programs to come up with, analysis. I haven't worked at one of those carriers in quite some time. The adjusters here, we typically, we look at it in terms of, what the injury is, how long they were injured, and just kind of explaining, all right, well, plaintiffs' firms in this jurisdiction usually value things at this dollar threshold. So I think it's helped bridge that gap a lot more. So we're not necessarily undervaluing or even overvaluing cases. I think we've had a lot of settlements, and it's really helped with training newer adjusters, folks who are coming into the insurance world that don't have any experience with that. How do you evaluate a claim? It's not necessarily 3 times the medicals.
Right, and I think that's like the old archaic way to do it. And I think, we've moved away from that. I think the challenge a lot of everyone has is it is subjective. Whenever I evaluate a case, and I'll talk to Wendy or other attorneys in the office, and I won't tell them my number, and everyone comes with a different number. And that just goes to show it's not a science. It's it's subjective.
Totally subjective.
I think one of the things that I find interesting too, you're coming from a litigation background. You said you teach the anatomy of a lawsuit to your young adjusters or your new adjusters. And one of the things that people get frustrated with that, attorneys have no control over, especially even in like Philadelphia, this area, and dealing with COVID, is the court issues. Put aside just like, the motion practices like in New York, just to get things moving sometimes, it takes time. Or, we have some courts that, you file motions for summary judgment and they just flat out deny them. There's no argument, there's no nothing. And, I think it's hard for an adjuster because you're looking at expenses and reserves and why is the court doing this? You made these arguments, what is it wrong? But I think, and I'm asking you, I think from having a litigation background, you understand those issues better.
That's a really good point, Wendy. I think for me, looking at, the motions that we're filing, what's the point of it? What's the purpose of it? Is it being used for a leverage purpose, a negotiation purpose? Do we think it's actually going to be successful? I think that's one of the things that I've really instilled here since I've joined Utica First, is trying to get an opinion from counsel. All right, what are the chances for success on this motion? What's the purpose of it? Let's just not necessarily file a motion for the sake of filing a motion. I think it's important to instill that upon the adjusters. Why are we filing this? Is it used again up against the backdrop of a mediation? Is it used to kind of leverage a position, or is it used because we have a legitimate argument that's well sounded in law, or is it just to drive up costs? So I really want the adjusters and the staff to understand the purpose of it, what the cost of the motion is, what the cost of the arguments are going to be, and think about that and make sure we understand what our chance of success is going to be.
Right. And I agree with that as well. I mean, like you look at a county like Philadelphia County, which is, terrible as for motion practice and a lot of things.
Right.
But, I've worked for clients that they want you to file every single motion regardless, every discovery motion, every motion for summary judgment. And in Philadelphia, you could have a slam dunk motion on paper, but it doesn't matter if no one's going to read it, and you file your motion, there's an opposition file that, just garbage, and it'll still get denied on the basis that there was an opposition filed to your motion. So you really have to know your venue in addition to knowing your case and your facts, and whether taking that step is really going to drive the ball forward, or you just kicking the can to the side just to do things.
I agree 100%. It's really knowing the venue. And I think, coming from the plaintiff side, I knew a lot of, the judges, and, just having that experience. All right, which way is the judge going to lean per se? Are we likely to get our motion granted, or is this a judge who historically never grants it or doesn't like to move cases along? Again, with these discovery motions too, it's really hard in the times of COVID, and it's hard to get that time before a judge to even get authorizations or get that discovery in. And sometimes we're encouraging our defense counsel, our panel firms to reach out and say, look, can we get this? Or are we actually going to have to file a motion? Like, take that extra step to do that.
Right. And I think that goes a lot towards, again, what we were talking about earlier, like working with your opposing counsel. Like I recently had an issue in a case that, the counsel wasn't getting me responses to discovery. And I kept saying to the client and to him, like, look, I don't want to file a motion. That's just silly. Like, just give me an idea when you're going to get me your responses, because I don't want to waste my time, my client's time filing a discovery motion. Just, we're not up against a hard, close deadline. So just, ballpark, can you get it to me in 60 days so we don't have to spend the time? And usually, that works. Unfortunately, sometimes you have counsel that just don't respond to those, even those like olive branches, and you're left with no choice. And that part frustrates me because I'm like, this shouldn't be that hard. This just.
Why do they want to do the work when you're going to do the work?
Yeah.
Until they're under the pressure of having emotion, they'll just sit back and you file away. That's the way this goes. And unfortunately, in some cases, I have kind of an interesting question for you, Mike. So, back in the days of law school, way back when we were there, did you ever think that you would be in insurance? Because I know the answer that I would say if I was asked this question, but I'm curious to hear what you have to say.
I never for a million years thought I'd be in insurance. Actually, I wanted to be a sports agent, but I didn't want to move away from the Northeast. So I quickly realized that once I went to law school that I'd have to move to either LA or New York City to really do that. So I don't know, I'm kind of a homebody and wanted to stay in the Northeast. So I kind of just, did some personal injury work. I learned a lot. It was a great experience, but the insurance industry really afforded me a lot of opportunities. So I think it's been great. But that's how it started. I never had the idea. I wanted to be like, Jerry Maguire.
Well, I mean, who really does have that idea? Like, if you're in law school, you don't think, at least I didn't think at that time, how important insurance is and how big it is. And I just had no clue at the time. I was like, no, I want to, draft agreements. And, I don't know. I didn't even know what the hell I wanted to do, but you're clueless. And then once you get into the work, you realize, oh, wait, this is like 90% of the work is pretty much driven by this. And it's a huge industry, and one with great growth. And I've talked to a lot of people in the insurance industry like yourself who are more concerned about getting younger populations into insurance and, promoting that this is a great career path. And it's not like super boring. It's actually the opposite, but it's very hard for them to recruit younger people because people don't think about it.
I agree. I mean, we've faced that challenge with all the carriers that I've worked with, just recruiting young talent. We've looked at different types of talent, whether it's folks with, maybe a criminal justice background who really want to get into that investigative piece, but, maybe don't want to be a police officer or in that field. So I've had great success with, an adjuster who had that kind of background, and, he wound up becoming an SIU adjuster, did a fantastic job and really had that curiosity developed. We've seen folks in retail just who have that customer service experience and know how to deal with folks and de-escalate situations. So we've looked there, but it definitely is a challenge. I think one of the things that's really important is when you bring in somebody, you need to train them on different levels, of the business. You need to teach them about underwriting. You need to teach them about, what an actuary does, about marketing, all of those things to, broaden their horizons and kind of give them a broader background. Maybe claims isn't for them, but they can still stay in insurance. So I think that's a good way to kind of foster that development and that growth in the insurance industry.
Absolutely. I couldn't agree more. And, and I think, when people see, or younger people see that, like how much growth potential there can be. And it's not just one thing. There's so many, opportunities available.
Absolutely.
Like I say we take this podcast, we send it to the dean at Roger Williams. I mean, I don't want to go in the middle of a snowstorm here, but I would love to go up because I think that when we do, I don't know if they called it career day or whatever out there, but you could, I remember I was just telling my other half last night about, I considered going into the JAG for a hot moment. I was like, could get my law school loans paid. I would, it could be in and out. And then I thought, well, wait a minute, I could be stuck in Oklahoma City for 5 years. And that's not really something I want to do. Or worse, I could have gone to Iraq. or,
Yeah.
Right.
Afghanistan at the time that when we were in school. So this could be something we could sell. I don't want to say sell, but promote.
I know it would be great to have like an insurance law class. I know that there are some law schools that offer that. I know that there are some undergraduate programs, but there's so much to learn. It's not just about torts. It's not just about property. It's about insurance coverage and interpreting contracts and civil procedure. It's all really rolled into one. So it would be a really interesting class.
I mean, think about it. I mean, how many classes did you take in law school that you used the information in those classes now? Or when I took civil procedure, I didn't understand what the heck I was civil procedure was talking about until I actually started practicing. I think very few things you carry on.
Exactly. I was like, what is a civil procedure? But, once you start practicing and once once I even got into insurance, I knew what this stuff was about, and it was like, all right, this is what, discovery is. And this is what, a 12B6 motion is. And this is what a motion for summary judgment is. It made no sense to me, when we first learned it. Maybe it was something that should have been, second year or something along those lines, but it made no sense to me at the time, but it makes much better sense. And torts, obviously, torts is important, and contractual law is really important too. But I don't know, I'm surprised with some of the stuff, even like taxes. I do think that there are some things, when we're talking about settlements and types of cases, whether it's personal and advertising injury case, discrimination case, where we're looking at attorney's fees or where somebody's looking for lost wages as a result of one of those claims. There's taxable elements to certain cases. So it's important to kind of understand that and explain that. And even in the negotiation process, okay, well, this would be taxed, or we could try to settle it this way. So, I think I'm a little surprised by all of the classes and how they've kind of come into play.
Yeah, depending on what you remember.
Right.
Like, I think I heard this somewhere. Sounds familiar. I think there should be, like, with you get the basis, and there should be, I know there are a lot of practical classes, but I think there should be more an emphasis on pushing the application of, however it may be, when, in my revamp of the law school system, that's
the art of negotiation. I think that's I always say, when you talk, I just actually talked to a university recently with another attorney of mine. And I said, best class I ever took was trial advocacy. Loved it. I've used it. But I knew I wanted to be in litigation. I knew that going in. I said, I knew I didn't want to do two things. I didn't want to do family law. I didn't want to do criminal law from the perspective of being a DA or a public defender. I do deal with it. I've done like some ARDs in the past, but I wanted to be a courtroom person. And I've done that in this capacity, but I love trial ad. Even if you wanted to be a transactional attorney, I think that was like one of the biggest skill classes that you could have. So they just need to add on to it, the art of negotiation. That really, that helps you. You need to understand some psychology to it, but there is, that understanding of like the case, the facts, jurisdiction, judges, a lot of things.
Right. I think one of the classes that really helped me was mediation. We had a great professor, and that really helped with negotiations as well. Just the art of negotiations, techniques, what to look for in a mediation. So, when I basically, one of the first cases that I got when, I was doing plaintiff's work, I was just go into a mediation, and I kind of knew what to expect. I was only in the firm for a couple months, and it's like, go handle this. And I wasn't nervous. I was pretty confident based upon, what I had learned in that class. And that was one of my favorite classes, all-time favorite classes.
See, that was probably much more helpful than when I went to my first mediation. I asked like a more senior attorney, I'm like, oh, I have a mediation coming up. Like, what do I do? What do I bring? And he's just like, crackers. That's not helpful. at all.
Who did you work for?
I will not name the person's
Yeah.
name, but that was the advice that was given to me. I brought more than crackers, but so circling back a little bit to your experience in claims, or taking your experience from being a plaintiff's attorney to claims, and using that in like what are your expectations of your outside counsel when you're sitting on the claim side and they're working on one of your files at Utica or one of your past employers?
I really expect responsiveness. I think that's really critical for us. Just having an idea of what's going on with the case. I want cases moved, whether it's a case that we see for a trial track or it's a case that we're looking for discovery. Get us the information. Keep us updated. I'm not a big fan of 12 to 20 page reports about every single nuance that's going on. Just get us the critical information so that we can evaluate a case, look at a case, evaluate our own liability, evaluate the witnesses. And I think another thing that's really critical is getting a budget, knowing what we're looking at in terms of what it's going to cost. I don't think enough carriers look at the cost benefit analysis of litigating. There are a lot of these $20,000, $25,000 cases that carriers are spending $50,000, $60,000 litigating. It makes no sense to me. Let's see if you can resolve those cases. And that was one of the most frustrating things on the plaintiff side. You'd be looking at a case where you have a low policy. It might only be a $25,000 policy, and you have fairly significant injuries. It might be a soft tissue, but it's a significant car crash, and the case might have a $15,000 to $20,000 value, but the carrier's stuck at $5,000, and they just litigate these cases endlessly, and it's frustrating.
Yeah.
I usually recommend 2 budgets. I always give the budget for my clients, either because I sit in GL and I sit in comp world, but if the case goes on, and depending on like the complexity of, whether they're catastrophic claims or things like that, you at least want 2 budgets coming through, sometimes more than that, because after discovery, I had a case where woman, this seemed like a minor case, something that could be settled. Injuries weren't that bad. And then they get cut. And then it left her in a worse condition. And at that point in time, I didn't just pick up the phone and call my client. I paid a visit. I actually got on an airplane, made a visit. And we talk about claims and stuff, but that was the front and center of this. Where is this going? Talk about jurisdiction, but budget, I think that's a really important tool that people don't understand in this industry.
That's a really good point, Wendy. We've actually started where we want the 2 budgets. We want an initial budget through discovery, and then we want it updated upon completion of discovery. Do we need experts? Are experts going to be involved? Do we need to do an IME, or is this a case that we can simply resolve? And like you said, a lot of things can change. It might be a simple case, but again, somebody undergoes surgery, or they have a complication, or they're unable to work or return to work, and things change. So again, we made it a point where we want an initial discovery budget, and then get us a secondary budget. I mean, you can't anticipate what motions are going to need to take place, and sometimes you get that budget up front, and attorneys have allocated for summary judgment motions. It's a rear end car accident. Why are we budgeting for a summary judgment motion in that? So I think that's another thing that my experience helps is telling a justice, all right, that's not a legitimate part of the budget. There's not going to be a summary judgment motion filed on this rear end car accident. We owe, we're legally liable. Our client's legally liable. So take that out of the budget. Don't consider that, and that shouldn't even be brought up. So I really think that's a good point, and that's a good way to look at it, having those 2 budgets.
Because it affects your reserves. I mean, you see that all the time. And one of the things that you get phone calls on is, do we have enough reserves, or we need to up the reserves? And at that point in time, you should have an idea of where this litigation is going at that point.
We talk about this a lot in our office that, within the first 60 days, you should be able to have a good grasp of what's going on, what your viable exit strategies may be, what you may need, and, experts or potential experts or no experts at all, within 60 days, you should be able to identify at least the bare bones and have an idea of like, this is generally where I see this case going. Sure, there might be curveballs, but you're going to know like, okay, is this a summary judgment case? Probably not. Maybe you should be able to identify those things right off the bat, or at least identify what you need to know to identify how you're going to resolve it.
I agree 100%.
So having said that, I probably know your response to this, but I mean, what are your biggest pet peeves from, from your outside counsel? I can imagine, recommending a summary judgment motion on a rear end accident is one of them.
Where it's your fault. That's pretty bad.
Most definitely. I think that's a big one, the summary judgment motion that's really not necessary. I understand, again, a lot of it is for negotiation purposes, but be clear about that. That's why we're going to do it. The demand is $2.5 million, and this is only a $200,000 case. Maybe it's to get them within the ballpark a little bit more, or make them work a little bit. But I think that's a really big pet peeve of mine. The other one is, okay, this is a defensible case. This is a case that we can take and get at 80, we have a 90% chance of getting a defense verdict. And I wouldn't recommend anything more than $10,000. And then boom, on the steps of the trial, we've got to pay $500,000 to get rid of that.
Yeah.
Be transparent up front. I think that's the most important thing. I'd much rather you say, look, there is some danger, there is some risk. Let's be aware of that here, versus making that change 3 years down the road. I mean, it's critical in terms of reserve development. We don't want to have a situation where, we have a reserve that's been set for a while, and all of a sudden we have to explain why we're putting up, $2 million, 2 days before trial. That's a real big pet peeve of mine.
And doesn't that make you sort of sniff fear too? Like, why are you suddenly now want the money? Are you now you don't feel confident in either the case, or you're scared to go to trial? Like, I understand trial is always it could be a toss, but sometimes they are necessary, usually not. But at that point I would be like, why suddenly you're changing?
Exactly. What changed? What did you not know? Or is it something that wasn't done? Did we miss something? I'm not trying to be critical here, but I've seen situations where maybe we didn't depose somebody and we should have, or maybe we should have had that medical expert, or maybe we should have done the IME. Sometimes there's some second guessing there. So, I'd say that's my biggest pet peeve.
Yeah.
It could also be something too. I had a trial a couple years ago, and pretty experienced plaintiff's counsel really went to trial because the demand was just outrageous. And I said, on my worst day, even if that jury came in with this number, you still win. I mean, that's still so much less than what they were, and they would not shake it. And then you get to the steps, and it wasn't fear. I think it was more, I know what I'm going to have to put in from a plaintiff's perspective. I mean, you could appreciate this. Like, you usually work on a contingency fee. So like, if you lose this, like, you don't get anything, and you're going to put all this time into trial, and the work that goes in, the doctor's depositions, the videotape, and all that. So maybe now we try to, work stuff out. I ended up trying it and won, but I just, at that point in time, like, that's where I saw the wheels clicking. Like, oh yeah, you're really going to make me get in this courtroom, and you're really going to make me work for my money.
I actually have a question about this, because I wonder this often, because I think different carriers have different feelings about it. But binding high-low arbitrations, I've had clients who love them. I have clients who loathe them. From a practice perspective, sometimes I think for the right case, they're a really good option. But people seem to have very strong feelings on both sides of the spectrum. So
I'm a thumbs down on that one. Done it twice in my life, and it was very rare, and it's not something
maybe I've just had good results. But yeah, what are your feelings on them?
I've never had really good results with them. The arbitrator wants business. but they usually tend to favor the plaintiff side. You know, if you're going to do an arbitration, it's very rare that you get a defense verdict. I've seen them happen, but it's rare. So from a carrier perspective, you have to know that going in. I can think of one recently where, again, the attorney was reasonable. He said his client was unreasonable, and he agreed to very reasonable parameters. It was, you know, like a parameter between $10,000 and $75,000. So we got that case resolved, and again, it was very reasonable parameters. It was a way of kind of, you know, getting us to that forum by agreeing to those parameters. And again, it came right in the middle where we thought it was going to come. It was just a client who, you know, wouldn't drop below the $75,000. You know, he wanted to get something in his client's pocket, and when we got that case, you know, resolved at the arbitration. But generally, not something I like to do.
Yeah, I like I said, I've had a bunch of really good results with them. I've had 2 defense verdicts on them with 0 lows. So
Wow.
I'm just hanging my hat on those 2 results. That worked out really well. So I guess I'm biased in that they can be fair. But everyone
Yeah.
has,
Sorry, I didn't mean to
No,
cut
go
you off.
ahead.
I think like one of the things is, if you can save your exposure or save, you know, an extra contractual exposure above the policy limit. I mean, there's a consideration there. If somebody's willing to, you know, maybe save something off the policy, we might consider it in those situations. I think that's another good use of it, you know, to kind of make sure that we're protecting the interest of our insured. You know, if you're looking at, well, the verdict value, it might be, you know, $1.3 million, and you can get an agreement where it's either within the policy or, you know, maybe $900,000 and you know, a high low of, you know, 100 to 900. I think in those cases, that's something that we strongly consider.
So switching gears a little bit, when, you know, you and I had talked on the phone a few weeks ago, and we were talking about how, you know, Utica's a smaller carrier, and there's certain challenges that you may face at a smaller carrier that you wouldn't necessarily, you know, come to heads with at a larger carrier. So I mean, how is it? I mean, you worked at some larger carriers, and now you know, Utica's a little bit smaller. How is it different for you?
Well, there's some good things, there's some bad things. I think one of the challenges that we have is, you know, we're a small company, we have a small staff. So, you know, we don't have the ability to maybe send out as many folks in the field. You know, when we have a cat loss, it can be quite challenging. This summer, we had significant losses due to Tropical Storm Isaias. We write a lot of business in the New York metropolitan area and in Connecticut, and a lot of homes were impacted by Isaias, which, you know, was not predicted to be a major storm. And we had over 1,600 claims as a result of this. And
Wow.
I have a property department that's only seven property adjusters and a manager. So that presented some significant challenges. You know, we couldn't get folks on the ground. But from it, you know, we learned, we put together a CAT plan. We've done some cross training of our liability adjusters to have them jump in. And we utilize and we rely heavily on independent adjusters. So, you know, we looked at which adjusters were mobile and able to get out in the field and get to our customers within, you know, 24 hours and really help out versus some of those independent adjusters that, you know, might have taken a week to reach out. So that was a big challenge, you know, just size and scope. When you have something catastrophic, there are definite challenges, and it's really good to have a CAT plan in place. Something that you can enact when there's a significant loss. So, and you got to keep updating that. And that was really critical for us.
And I think that's so great though too, that you know how to use your resources, and you know, maybe your litigation claims aren't super busy, so you can, you know, use those resources where they're needed at the time. And I think, you know, that's just something that, you know, a smaller outfit has to be able to do. I mean, your job is not just your one job. You know, you have to put on a few hats.
Absolutely. I mean, we part of our plan is we're going to cross-train underwriters and some of our marketing reps to jump in and, you know, take calls, answer claims, issue payments, you know, train them in the system. So we've implemented that plan, kind of an all hands on deck approach. You know, I worked at some of the big carriers. They had a CAT team, and, you know, they had 200 adjusters that they would deploy to an area, and, You know, it was great. You'd get cat pay as a cat adjuster, but and half the time you'd be kind of sitting around waiting for the cat to happen. And we just don't have that capability being such a small carrier.
Is there one particular like insurance that you really liked? I mean, I know you're doing like some cat claims, but from your other days, are it's kind of all the same to you, or?
I think it's really all the same. I love general liability claims. I just, you know, there's something different, something new all the time. I also like the bad faith element too. You know, I think, again, coming from the plaintiff's bar, you know, we had to get creative. Sometimes we'd have a small policy, and, you know, Rhode Island, you know, we would always quote a Sermley versus Allstate, and we try to trigger extra coverage. And that was one of the things that really spent a lot of time on, and really I learned from, you know, my boss when I worked in private practice, you know, just kind of trying to trigger and be creative. You know, we only have a $25,000 policy, but we have, you know, a fractured femur. And so you know, I try to be aware of attorneys who are trying to set up the insurance carriers in those cases too. You know, they send limited information, and it's a time limit demand, and you know, you don't have the ability to, you know, properly investigate the claim, and you have to make a quick decision on some of those cases. It's not so much in the commercial world, but maybe in the auto world, or even some homeowners cases where you have smaller policies. So I really was always interested in that specific field and space.
And I would say, like, I think I've talked to a bunch of people that they're getting those time limit demand letters, you know, is one of those things that keeps them up at night.
They always come in like, you know, right before you're going on vacation, you know, right before Christmas,
Yeah,
when they know we're going to be out of the office.
Yeah, and then there's always I've heard people say there's always a fear when it gets to like maybe a younger, less experienced adjuster, and they might not know like how to handle it too, and may not, you know, respond as appropriately as they should.
Absolutely.
So, you know, you spoke a little bit about like, you know, some of the issues that a smaller carrier may have as to like responding to like, you know, catastrophic losses. But what about benefits? I mean, I imagine, you know, there's a lot less red tape, and, you know, you can probably run through whatever channels you need a lot easier than you may at like a much larger big box carrier.
That's a really good point, Megan. You know, we've gone to mediations where, you know, we've roundtabled the claim, and usually, you know, we like to get multiple input from multiple people, whether it's, you know, myself, the supervisors, the adjusters. We like to invite multiple adjusters to participate and get ideas. And people have varying degrees of experience. They have various backgrounds, so they might have a different take on something. So, you know, we come up with, you know, a value for our evaluation, and we give the authority. And it's frustrating when, you know, you have a carrier that might be a bigger carrier, and you have to go all the way up to the vice president at that carrier, and they come with only $20,000 in authority. And it's a case where there's a significant exposure. It's very, very frustrating. You know, it wastes a lot of time at the mediations. I've gone to multiple mediations where, you know, we've come prepared, we've come with the appropriate amount of authority, and, you know, we have other carriers who don't have the authority. And it's not just posturing. You know, the mediator says, look, they legit don't have the authority. It's not their way of negotiating that they don't have the authority. They've had to make calls at 6 or 7 o'clock at night to the vice president to get that authority. So it can be very, very frustrating. You know, I've seen a lot of cases and, you know, in bad faith verdicts or UIM cases where carriers haven't stepped up or don't send somebody with authority, and it can be a huge waste of time, and it's highly frustrating.
It's more money.
It's more money.
It's more money. And that's why I think that's, you know, goes back to what you're saying about budgeting, you know, reserves, things like that. If you get that on the onset, you shouldn't be at the end of your case. You shouldn't be getting into that mediation room and you're like, I don't have any authority. It's like, I've been telling you this, like, you have to see this is facts of the case. You're not going to get any, it's not going to go any other way.
And there can't be anything more annoying that if you've done everything you were supposed to do, you set out your budget, you're nothing blew up, you know, you stayed within your parameters, you have your authority, you're at the mediation, you have co-defendant there, and it doesn't resolve because they can't get their ducks in the row, and now you've wasted just exactly what Wendy said. You've wasted all this time and money, and it wasn't because we didn't do what we were supposed to do. And and then suddenly now you're talking, oh well, can we just get out? And then now you're trying to package it so you can help your insured and resolve it, but it's not the ideal resolution for the whole case.
It's not. In those cases, I like to send the mediation bill directly to the carrier and say, you wasted my time.
Yeah.
Here's the bill. Why don't you pay it? We're not paying it, or pay us back. You wasted our time. And it gets noticed. And I think that's a good approach that I've seen on cases where, again, they showed up not prepared. And here's the bill. We came ready. You wasted the entire mediation. It wasn't fruitful. Take care of it. And I'm not afraid to do that. I think that's a good approach. I think another thing too is just the approachability. With a smaller carrier, I work with all of the claims adjusters, the supervisors, the claims manager, and just having the ability for folks to come into my office and ask for ideas and talk about a case. That's not afforded at some of the bigger carriers. Some of the carriers that have remote offices, they never even see the vice president of claims or whatever the claims leader is, or the assistant vice president. And there's just so many tiers that you have to go through to get authority. So I think that's another thing, and it can be intimidating to go see somebody that you've never met, or you have to go ask for $1 million. I don't like to operate in that sense. I like to encourage folks to come in and let's talk about a case. If you see the case valued at $1 million, let's talk about it. Let's figure out why. Is that a reasonable evaluation? And let's try to get the case resolved.
And I think that same sentiment runs over to law firms, at least in my experience. Like, we're not a huge law firm, but I think, it's much, the atmosphere, you can collaborate much more, because it's not like, oh, I don't know that person, in that office down the hall. Like, who everyone is, and everyone's willing to work together. And I think when you have that collaborative atmosphere, and you can work as a team to get things done, the whole machine kind of operates more smoothly. And having that feeling that they can come into your office or whoever's office and say, look, this is what's going on. How do I handle it? I think it's, speaks volumes to just the whole operation.
So Mike, if you were to tell a young attorney or somebody that's a young person that's looking into going into claims, what would be like the best, advice that you would give them?
I think claims is a really good career for you. It really can hone your negotiation skills. It can hone your advocacy skills. It can hone, your skills on civil procedure, torts. So there's a lot there. We've had a lot of adjusters who started out as claims adjusters and, went to law school or were going to law school as claims adjusters. So I think, either way, whether you come in as an attorney or you go and get your JD, and you pass the bar as an adjuster, I think there's advantages to it. I mean, it's a very, it's an industry with a lot of growth potential, and there are a lot of skill sets that you can utilize that law background, your advocacy background, with. So I would certainly encourage it. There are a lot of attorneys out there, and it's hard to kind of get into, firms sometimes. There's a lot of competition. And so it's just another thing that maybe people don't think of, when they're going to law school, going into the insurance industry. So I think that's something that you should give some thought to. For folks who don't want to litigate, it's another good opportunity. I had, in the past, I had a working mother who litigated for a couple of years. But, as her kids grew up, she didn't want to do that. She wanted to have something that afforded her the opportunity to kind of be more active with her children. And so she did that. And she was a fantastic adjuster, very, very bright. She was a really great attorney. And, this is the career path that she wanted to do. And, she's still handling litigated claims. And you get to make the call. We're the ones with the authority, too. That's something that, a lot of folks don't necessarily realize. We give the authority to the attorneys saying, okay, this is what you're getting that attorney from. When I was a plaintiff's attorney, I never realized it worked that way. I always thought the money came from,
You thought
you
it
know,
comes from my pocket?
comes from your pocket. So like that was one of the things that you quickly realize. So you're the one really calling the shots and controlling what's going on and dictating the case. So it's really a good way to kind of get that understanding, especially if you want to be a tort lawyer or even a personal injury lawyer. It gives you that opportunity, or want to become a defense attorney. You understand the business, you understand what goes on, and having that knowledge is critical.
Yeah, and I think that's a good point too. Like the claims adjuster is really driving the litigation. I mean, we provide our best recommendations, and we do our evaluations, but ultimately the decision is up to you. And all we can do is say this, these are your options, or this is what we recommend, but we can't do it if you don't want us to.
Right.
At least we shouldn't be.
Right. And that's one of the things I want to instill too. I want, the adjusters to drive the case versus the attorney, filing the motions for summary judgment on a rear end car accident. It shouldn't be that way. Again, we should be the ones driving the bus per se.
So I want to end this on, because we're running a little bit out of time, but outside of, work, what does Mike do for fun?
I have two great boys. They keep me very, very active. I have, he'll be 7 actually next week. My youngest son is Alex. My oldest son is Jake. He's 9. My wife has been very, very supportive, Jess. So shout out to all these guys. I love sports. So I'm very active with my kids. Both my kids play basketball, baseball, and football. I've coached their basketball and baseball teams. I love playing sports and watching them, and spending time with them. Coaching's always been one of my passions. In the past, I've been a baseball umpire as well. So you kind of have to mediate those disputes on the athletic field. But I've kind of retired from that now to actively coach my kids. I love following sports. I'm a big Providence College Friar basketball fan. Love the Red Sox. Love the Patriots. We live in an area.
Even without Brady, you got Kim going on there.
It's a little tougher this year.
I'm an Eagles fan. You don't have to tell me.
Oh, I know, but I still have nightmares about that Super Bowl 2 years ago.
I said when we were in law school, you would have been out that year because I'm a year behind you. When the Eagles played the Patriots, I called my landlord. We had a nice white house by the water. And I told him, I said, Vic, if the Eagles beat the Patriots, I'm going to paint the house green and white, and I'll repaint it before I move out and graduate. That didn't happen. But.
It didn't happen. See, if you were there in 2018, though, you could have painted it green and white.
Yeah.
That would have been a big job.
I don't care. That's how excited I was. I went home to go watch the Super Bowl, but I was up there at the time.
Yeah, the first Patriots Super Bowl, I think it was my first year in law school. So that, we were an underdog, weren't expecting anything. The Patriots were terrible up until then. Really, in my lifetime, they went, I guess, 97. We had a chance, but just I didn't have any aspirations of a Super Bowl championship at that time.
Yeah, but you had the Red Sox that broke the curse.
It was 2004.
Yeah, I remember. I was up there. They burned the mailbox down the street from me. I'm not kidding. I was like, who burns the mailbox?
Well, thanks so much for coming on. I really love talking to you today. And you're welcome to come on any other time. If you have anything else you want to chat about, we're happy to have you.
No, I appreciate it, Megan. I appreciate it, Wendy. It was great to be a part of this. Did a great job. I'm really thrilled. I'd be happy to come back on.
The only requirement is before you come on next time, you have to go back and find some dirt on Wendy and just dish it to us, please.
Oh boy.
Find some old pictures or something.
Well, in the insurance industry, we can always find dirt, right?
Probably.
So
I'll have to go back to one of our colleagues. I know where I can get the dirt.
Yeah, we have a few connections.
That's what I'm hoping for. But
in fact, I talked to Dan Giannotti. He's down in Tennessee, which is our home office is in Tennessee. So he just got back into practice.
Huge Eagles fan. Huge
Oh
Eagles
yeah,
fan right
that's
there.
how we bonded. I was like, I had like him, Seth. I had like very few people that were like huge Eagles, Philadelphia fans. It was great. Watch all our sports together.
That's right.
Well, have a safe drive home today. Drive carefully. It's
Hey, you better get going.
Yeah.
Yeah, I get some time. I get some time. It's not supposed to hit until 7 or 8 o'clock tonight.
Oh, okay. And we're
Ours
looking
is
at like
coming soon.
yeah, like Wendy, I think you're supposed to get like a foot.
Yeah.
Is it
Yeah.
starting to snow yet down there?
No, just
No.
cloudy
Alright.
and
Same
Yeah.
thing here.
My kids are looking out the window waiting, and I think they're pretty disappointed where we are. But
No snow days anymore for our kids. They're all remote. So
I know. That's what I told them. Too bad.
we got a court morning. You know, I actually have court in a little bit virtual. Everything's pretty much virtual. I think I've worn a suit 3 times since this pandemic happened. I went from every day to like now like 3 times, and they were giving snow warnings out, and I'm like, for what? If you can't show up, you can't get on your Zoom. Where are you?
either the judge or the clerk or the magistrate, they've either got to go in, a lot of them are going in. So
And there are going to be high winds. Power could go out.
Yeah.
that's right. We always lose power. So hopefully, knock on wood, will be all right. 5-mile-an-hour wind, we have no power at home.
Well, thank you so much. And
Thanks, Mike.
yes.
Thank you.
Bye.
Really appreciate it.